Our think tank tonight, ooh, it's a good one. Criminal defense attorney Ecleynne Mercy is here. Andrew Warren, Hillsborough County State Attorney in Florida, and the legend, Darrell Cohen, criminal defense attorney and former prosecutor. Welcome all. You'll be here for the next hour. Thank you for your time. We're starting in Louisville. The tension is building. Andrew, I want to go to you. You're an elected official, a state attorney. The way this is being handled, why not just say, we're going to announce the charges on blank day? This cat and mouse game being played, well, we're not sure when it's going to come. Meanwhile, everybody is bracing. There seems to be unneeded tension.
Well, I'm hoping that what's going on is that the people who know what the decision is going to be are talking with community leaders. I mean, there's going to be people upset no matter what the decision is. And if they decide not to charge the officers here, you're going to have a lot of people really upset. And of course, the risk of protests and even worse, devolving into violence. So the key here is to take advantage of those existing relationships that have to be built long before the decision is made. Make sure that you're talking with key leaders in the community. Make sure you're preparing people for the decision and having those advocates who can maybe calm down the community if it's not the decision that they want. Hopefully that's what's going on right now as they're preparing for this news to be revealed.
Ecleynne, Breonna Taylor sitting in her home with her boyfriend, minding her own business, ends up dead as a no-knock warrant is executed in Louisville. Nobody can look at the facts of this case and say that it isn't heartbreaking and disgusting on many levels. But was the law broken here by those officers? It's not as though the no-knock warrant was illegal and they were fired upon first.
Well, there's a chain of events. There's a chain of people that should not have jobs right now. The issue is that it was a judge that signed that warrant. It was a judge that signed the warrant. It was a magistrate that said that it was enough for a no-knock warrant, and that's a problem. Then we have officers who bring it to a magistrate knowing that they don't have enough. That's a problem. Then we have supervisors that allow officers to make the same mistake repeatedly. That's a problem. So we have a whole litany of things compounded on top of one another to the point that we have a dead, EMT worker who wasn't even given aid while she laid down bleeding and dying to death. Like, we have a lot of people that should be unemployed right now. But most importantly, we have officers that should be charged for the gross negligence that they displayed on that day.
One of the officers, Officer Mattingly, Darrell Cohen, sent an email to the department this morning at 2 a.m. this morning, and in it he talks about basically saying, I'm sorry that you people are in this predicament. You do not deserve to be in this position, the position that allows thugs to get in your face and yell, curse, and degrade you, throw bricks, bottles of urine on you, and expect you to do nothing. It goes against everything we were taught in the academy. Your civil rights mean nothing, but the civil rights have total autonomy. It's not us against society, but it is good versus evil. This email now has been widely circulated, and it seems to be a bit tone deaf, don't you think?
Ted, it seems to me that the statement is accurate, but the statement is not accurate for the facts that went down in Louisville with Breonna Taylor. Now, I understand the no-knock warrants. I'm a former prosecutor, former assistant state attorney, former assistant DA, and I get the no-knock. That's appropriate because the cops, the narcs, the police, law enforcement does not want to be gunned down. But in this instance, we're going to have to wait and see what the decision is as to whether or not these police officers, 1, 2, or 3 of them, are going to be prosecuted. And if so, what are the charges going to be? I wouldn't be surprised, regardless of how it goes down. I'll be disappointed if how it goes down creates not anything less than riots. If it creates riots, it will be horrible. If it creates people that are protesting, that works for me and it works for this country, but it doesn't work if it escalates into violence.
Let's listen to the mayor of Louisville, Greg Fisher. He basically says that,
We've
there he
received
is.
no word from the Attorney General about when he will make his announcement or what his findings might be. We hope that announcement, whatever it is coming soon so our city can learn the facts of what happened that night, begin to heal, and take the next steps in the ongoing fight for racial justice and equity. Representatives of my office and LMPD have been in contact with some of the protest organizers about the measures being put in place. My hope is that we will continue to see peaceful, lawful protests, which is what we have seen the vast majority of these last 100+ days and nights. I ask everybody to use caution and don't base your own plans on unfounded and uninformed speculation online, and please don't spread misinformation either.
Andrew, Ecleynne was talking earlier about what transpired in this case with the no-knock warrant being approved without, when it shouldn't have been, because the person they were after, they had already taken into custody that evening. They were not, they supposedly were after this drug dealer who wasn't there because he was in custody. From your vantage point, leading a prosecutorial office, how difficult is this situation for the folks in Kentucky as they try to meander through this?
It's a really difficult situation. And part of the problem here is that everybody is looking to whether charges are filed as if this is somehow going to solve the problem. As Ecleynne made the point, you have to look at what led up to this happening in the first place. The fact that the targets of this investigation were not Breonna Taylor or her boyfriend. The fact that there were questions about whether any suspicious activity had actually been observed in and out of her apartment. You look at what happened after the fact, inaccuracies in the police report, inaccuracies about whether there was body camera footage. So I know that there's this palpable frustration right now in the country. I mean, we are sick and tired of seeing innocent Americans, especially Black Americans, who have lost their lives. But the decision whether to charge these officers, as important as that is to achieve justice for Breonna Taylor, it's not going to bring her life back, and it's not going to prevent other innocent lives from being lost. You have to do the hard work to look at the systemic changes here that are going to mitigate against this happening again. De-escalation techniques, better investigative techniques, thinking about no-knock warrants and how they're used, if they're used at all. These are the things that lead to big picture changes so that we don't have any more Breonna Taylors ever happening again in our country.
Ecleynne, the civil case was settled. And as part of that, there is going to be change, supposedly. They're eliminating the no-knock warrants in this jurisdiction, and there are several other things tied to this civil agreement. Do you think that might be enough here?
No, I have a problem. I have a problem. Even with the civil agreement, usually when you have a settlement, it's in there that you don't talk about the number. But Louisville was really quick with telling the amount of money that they settled for. But what I really have a problem with, and I have to bring it up, was that email. The fact that the officer was able to send that email and was not in custody because he's out on bond, because that is clearly gaslighting. He was trying to gaslight. You are not supposed to intimidate witnesses or potential witnesses. When you send an email that goes around to your former employers and former employees, that is you're trying to send a message. It doesn't matter whether charges are brought up or whatnot. He has an attorney, and the fact that he did that is a problem for me. That means that you are gaslighting. That means that you are putting out there, you have the ulterior motive. You have another mission. You are not making it about Breonna Taylor, who died. You are making it about being a martyr for something that did not happen, that should not have happened. This was gross negligence. Somebody died. Somebody needs to pay for it civilly, which they did, and I believe it should be more, but somebody needs to pay for this criminally as well. And I do believe that we have to go systemic. It has started from the magistrate not even being able to see that none of this was correct, to the fact that the actual person that they were trying to apprehend, as my colleague stated, was already apprehended. We have a problem. Louisville has a problem. And the fact that there's still the person who's under investigation for this, it should be under investigation, is sending out emails, should bother everybody. It should have never happened.
Okay, well, we'll wait and see what happens over the next few days. I think, as Daryl said, no matter what happens, it is not going to satisfy everybody. We're going to step aside and take a break. When we come back, we're going to talk about the prosecutor up in Minneapolis, booted from the George Floyd case. The state wants him back on. That's next. Welcome back to Court TV Live. The judge in the George Floyd case ruled to remove Hennepin County Attorney Mike Freeman during the defendant's last court appearance. Now, the state wants the judge to reconsider. Why was the county prosecutor removed in the first place? And what's next? Here's Court TV crime and justice reporter Julia Janae.
Our office has been flooded with calls, many as 1,000 a day, as well as email and social media from people in this jurisdiction, in this state, and throughout the country. The main question is, what are you going to do about the murder of George Floyd?
Elected Hennepin County Attorney Mike Freeman's office is tasked with handling one of the biggest cases in Minnesota history, and Freeman is not allowed to touch it.
As many of you know, the Hennepin County Attorney's Office is one of very few prosecution offices in the United States who have successfully charged and convicted and obtained a guilty verdict against a police officer for unreasonable use of deadly force. We have developed a detailed plan for that prosecution.
Freeman is speaking here months before being disqualified from the case on September 11th. The presiding judge booted Freeman and 3 of his assisting attorneys off of the George Floyd murder case. This decision came after defendant Derek Chauvin claimed the top county attorney violated the advocate witness rule that states a prosecutor cannot be a courtroom advocate for the state and a witness in the same trial. 2 days after Floyd's death, Freeman and his team interviewed the medical examiner who completed the autopsy, but their decision not to include a non-attorney at the meeting would have ramifications.
Prosecutors customarily meet with witnesses. Sometimes they have their investigators there. They're supposed to have them there, but they don't always do that. And, normally you don't put yourself in a position of being a witness, especially in a situation as this is, because the only way you can become a witness is if the witness testifies to something that's different than the notes that you give them.
Minneapolis criminal defense attorney Ecleynne Tyler says it's rare to see a prosecutor eliminated over this rule, especially when the witness is a regular on the stand. But at a pretrial hearing, the judge banned Freeman from participating in the trial and even from talking to the rest of the prosecutors about the case.
I think it's a shot over the bow. I think the judge wants this case to be as clean as possible, and I think that the warning shot will be well heard.
Minnesota Attorney General Keith Ellison's office had already taken the lead in the courtroom, but it was expected Freeman would have a hand in the prosecution as well. Assistant Attorney General Matthew Frank defended Freeman's actions, calling the medical examiner a routine and government witness who is not expected to change his findings at trial. Now the state is urging the court to reconsider its order and allow the 6th-term official to fulfill his promises to his constituents.
We are going to investigate it as expeditiously, as thoroughly and completely as justice demands.
All right, still with me, Ecleynne Mercy, Andrew Warren, and Daryl Cohen. Andrew, to you here, you are a state attorney in Hillsborough County, Florida. How sloppy was this mistake, and what do you think of the judge's ruling? Should he have bounced this prosecutor?
One of the first things you learn about trying cases is how not to screw up the trial. And you got to do everything to protect the investigation, protect the integrity of the prosecution. Here, the attorneys, it's best practice to have a witness there, like an agent or a law enforcement officer, an investigator, so that you're not making yourselves out to be potential witnesses as an attorney. That being said, however, it's not like they committed some cardinal sin. It is commonly done. It's not like you can always follow that best practice of having a third person there. And the reality is that even if you had an investigator there, the defense argument that, well, the attorney has made himself a witness in case the medical examiner changes his or her testimony, well, there's still a witness even if there's another witness there. The bottom line here is that the judge probably overreacted a bit. Making sure that the attorneys can't participate at all in the prosecution is a really extreme remedy. It probably wasn't warranted here. There are other ways that this could have been accounted for, in the sense that making sure that the attorneys weren't witnesses in the case. But again, even though they may not have followed best practices, I think this is something that probably should be reversed, unless the judge is just really, really being extremely conservative here.
Daryl, you've been involved in high-profile cases. This is a very high-profile case. How does that change the way a judge rules in especially something like this in a pretrial motion?
I would like to say not at all. But the truth of the matter is, the court of public opinion, which happens to be the public, makes a big difference. And this judge is likely elected. This judge is, in my view, overreacting. Prosecutors all of the time interview witnesses. Most of the time, much of the time, they have another person there, but it's not at all unusual for a prosecutor to go over a witness's testimony, what they believe he or she is going to testify to. That is just not, in my view, the right thing for the judge to do. My thought, the judge needs to reconsider. But think about this. What if this is not the first time this judge has crossed swords with our prosecutor? What if this case is the high-profile case that it is, but the judge has said to him in previous cases, if you do this again, I'm going to disqualify you? That's what I'm hearing. That's what I'm smelling, and that's what I'm thinking.
Ecleynne, when Daryl Cohen smells something, it's usually something there. What's your take? Does the judge hate Mike Freeman?
No, I think that like Daryl and my colleagues stated, this happens often, and because of this, it would be considered a harmless error. And not to mention, we're doing this during the season of COVID, so it is a pandemic. So bringing in another person, although we would like a witness, I think that the prosecution could bring in the fact that it was COVID. You don't want to jeopardize other people while, at least when questioning witnesses that have already been on the stand, who could testify to, having been on the stand before. But I just feel like the judge is covering his bases. This is not just a case. This is the case that when we look back, we're going to see George. I won't remember half of the cases I've tried, but I will always remember George Floyd. So that's how pivotal this case is. That's how clean we want it from start to finish. So I can see why the judge would make that ruling, and I can see why he would need time to make sure that, hey, if he does bring the prosecutor back in, to have time to have the case law stating that this is harmless, stating, really delineating out that he has done the right thing. So as Daryl stated, the court of public opinion doesn't have qualms with it before the trial actually starts.
Another decision the judge is going to have to make is, should these four be tried together? Is Chauvin different? Daryl Cohen, should Chauvin be tried separately, at least, than the others because of his role?
I think, Ted, it depends on what side of the fence you're on. If you're on the prosecution side, he needs to be tried with everybody. Why? It's easier. Why? Because bad testimony against one of his co-defendants will rub off on him. From the defense side, I want my client clearly delineated. I want him separated from these people, because whatever that testimony was against him is not going to work, because it was against them, not him.
Okay, coming up, another big case, another big decision by prosecutors, the Ahmaud Arbery case, when we return. Stay with us.
Welcome back to Court TV Live. I'm crime and justice reporter Julia Janae with your legal news break. In California tonight, the widow of NBA superstar Kobe Bryant has filed a new lawsuit in her husband and daughter's death. It's against the Los Angeles Sheriff's Department. Vanessa Bryant says the photos of the January helicopter crash that killed Kobe, their daughter Gianna, and 7 others were leaked to the public. The lawsuit accuses 8 deputies of taking photos on their personal phones that allegedly includes images of the slain victims. The lawyers for Vanessa say those photos were shared in a setting that was unrelated to the crash investigation. It also cites a bartender who claimed to have overheard a deputy using the photo to impress a woman. The sheriff's office previously said that it has conducted an internal investigation. The lawsuit against the LA sheriff alleges he told deputies to delete the photos to avoid discipline. The civil claim seeks undisclosed damages for what it calls civil rights violations, negligence, emotional distress, and a violation of privacy. And an arrest in New York has international implications. Prosecutors are charging a man with reportedly spying for China, and the suspect is an NYPD officer. Prosecutors say 33-year-old Bamanajay Anwang gave China information about Tibetans living in the New York area. They also say he offered Chinese officials access to senior NYPD personnel, all in exchange for money. Ang Wang reportedly worked with a member of the Chinese consulate in New York, but officials say he was caught red-handed after investigators recorded their communications. The officer served in both the Marines and most recently as a reservist with the U.S. Army. He also held a high level of security clearance. He faces up to 55 years in prison if convicted. And the man responsible for the singer John Lennon's death is revealing why he killed the Beatles legend. During an August parole board hearing, Mark David Chapman said he killed Lennon due to his fame. The convicted murderer says he was, quote, seeking glory. He went on to call his own actions creepy and despicable and deserving of the death penalty. Last month, New York State corrections officials denied Chapman's parole for the 11th time. The board said they found Chapman's statement that infamy brings you glory to be disturbing. Chapman shot and killed the former Beatle back in 1980, hours after Lennon autographed an album for him. He's serving a 20-year to life sentence. His next parole hearing is scheduled for August of 2022. That wraps up your Court TV Legal News Break.
On the docket tonight, the Ahmaud Arbery case. The prosecution has taken the death penalty off the table against the men accused of, according to them, hunting down and murdering Arbery in their South Georgia neighborhood. We'll talk about that with the think tank in just a bit. But first, let's go back and look at the video that was captured by one of the defendants. We want to warn you, the video is graphic, but investigators and prosecutors say this video will help prove their case. Take a look.
In the first few seconds of the Ahmaud Arbery shooting video, it's clear that Roddy Bryan, the person recording, is also driving. 5 seconds in, we see Ahmaud for the first time. He appears to be running at a consistent pace. At 9 seconds, we get the first look at the truck stopped in the road. The driver's side door is open. The man standing outside is Travis McMichael. He is armed with a shotgun. Standing in the back of the truck is Travis's father, Greg. He's armed with a handgun. Two things to notice here as the camera starts to move erratically. Watch Ahmaud as he appears to realize what's in front of him. He decides to go around the truck on the right-hand side to avoid Travis. Now, watch it again and think about Roddy Bryan, who is shooting the video. He keeps driving towards the evolving situation and then listen. That sound raises the question, is Bryan cocking a handgun from inside the car? Bryan maintains he was unarmed. As we break down the next sequence frame by frame, we see Ahmaud on the passenger side of the McMichael's pickup. In the next frame, we can only see Greg McMichael, who appears to be holding a phone in his ear with his left hand. We know his right hand is holding a pistol. Now we see that Travis McMichael has moved from the driver's side to the front of the truck with his shotgun, presumably to confront Ahmaud. His right leg shows his knees are bent, his head is looking forward. In the next frame, we see Travis has now stepped back, and this is when we hear the first gunshot. The next frame clearly shows that Travis is being pushed back and Ahmaud has his hands on the rifle. Watch as Ahmaud releases his hands and hits Travis, first with his left hand, then with his right, as the struggle moves out of frame. Greg, meanwhile, now in the back of the pickup, puts his phone down and appears to ready his pistol. Then another shot. And we see smoke coming from the struggle. At 27 seconds into the video, Travis and Ahmaud can be seen again struggling over the rifle. Watch right here. Ahmaud pulls his right hand off to try to hit Travis. This gives way to the final shot. The final frame of the 36-second video shows father and son each holding a firearm standing in the street with Ahmaud Arbery laying on the ground, dying.
My guests are still with me, Ecleynne Mersley, Andrew Warren, and Daryl Cohen. The news today out of Brunswick, Georgia, is that the prosecution is not going to pursue the death penalty. Andrew, you're the state attorney in Hillsborough County, Florida, where there is a death penalty. What goes into that decision to pursue the ultimate punishment?
Whether to seek the death penalty is the most difficult and polarizing decision you can make as a prosecutor. And make no mistake, this crime is awful to watch. It shocks the conscience. It's a gut punch to every American to see what happened. But when you think about whether we should seek the death penalty, it should be reserved for the worst of the worst, the most aggravated, least mitigated capital offenses. And when you think of the typical types of cases that qualify, it's where there's excessively heinous, atrocious, and cruel, torturous cases, where it's cold, calculated, and premeditated, so heightened premeditation, where you have a vulnerable victim such as a young child, where you have a serial killer with multiple victims. This case, as bad as it is to watch, and as disturbing as it is to know that it was racially motivated, probably doesn't meet those criteria for the worst of the worst, most aggravated and least mitigated. Now, that being said, when you're seeking the death penalty, it's merely a decision of whether the defendant is going to die in prison of natural causes or at the state's hands. And here, these two men, if we prove the case beyond a reasonable doubt, they're going to die in prison at God's hands, just not of the state's.
Ecleynne, what's your take on this decision?
Oh, I mean, as a defense attorney, I'm just by nature, I'm just opposed to death penalty. I don't think you should, give death for a death. It makes no sense. I do believe that they did the best decision by that, as Andrew stated, that this, the death penalty question is a polarizing question, and especially with tension so high, you don't want to add another layer to that. So I understand, I understand why they wouldn't pursue the death penalty in this case.
Daryl, another part of the equation with this is the jury. Typically a death qualified jury is a more conservative jury, and that typically works to a prosecutor's advantage. In this case, it's sort of reversed, where a more conservative jury would actually work better for the defense, possibly. It could be argued. Do you think that played into this decision at all?
Ted, I think what played into this decision is SMART. The prosecution, the DA's office, has a case of the smarts. What am I talking about? Let's go back to Orlando. Let's go to Casey Anthony. When the jury was qualified for the death penalty, she was found not guilty, not innocent, but not guilty. In this instance, I think that by not qualifying the jury for the death penalty, it makes a much easier case to prosecute. It's a lot easier for people to say guilty when they don't worry about the defendant perhaps getting the death penalty. And by the way, I'm very pro death penalty. Former prosecutor, current defense lawyer, I'm very pro prosecution and very pro death penalty. Not in this instance. Good move, smart move.
Another decision that is going to have to be made here is should all of these defendants be tried together, and should this trial take place in this small rural Georgia county? Well, in this case, you don't have the defendants wanting to move this trial out of their county, which is a little bit odd, because typically a defense attorney would say, oh, everybody knows about the case. I can't get a fair trial for my client. But Andrew, it's clear why. They would much rather be tried in front of and judged by their peers, and their peers are rural Georgians, not Atlantans. Where do you think this is going to be tried ultimately, and do you think they should be tried together because Roddy Bryant really does have a little bit of a different role?
I do think the case is going to end up being tried where they are in New Brunswick because they're entitled to have the case tried where they live in their jurisdiction. And it's going to be hard for the state to find a compelling reason to change venue just because they're worried about jury sympathy or because the community may know these two defendants. That being said, the case should be tried together. And I know Daryl made the point before, if you're a prosecutor, you want it tried together for George Floyd, and if you're the defense attorney, you want it separated. But the law is that the case should be tried together. These are one set of facts, one set of witnesses, one heinous crime that was committed. Both of these defendants should be tried together. It should be a no-brainer for the court here to hold this as one single trial against all the defendants. And if they have to do it where the crime occurred, that's probably the right decision too.
Ecleynne, do you ever see a prosecutor ask for a change of venue? And do you think it would happen here?
No, I've never seen it. And I could see why they would ask. I mean, this is the same prosecutor. Again, it's an outside prosecutor that's dealing with this case because the prosecutor that had it initially let them go and then wrote and then we had that 7-page letter of how they weren't responsible and how this was justified. So I can see why systematically this would not be the best place to try this case because we've already seen the problems with the system. We don't know how far it goes. We don't know if it's through the prosecutor's office, if it's also with the sheriff's department, if it's also with the judgeships. We have no idea. So I can see why you would want it out there, why you wouldn't want it tried in Brunswick, but I believe it's going to stay there. I believe because it's the same transaction and occurs from start to finish, all three were involved, so they all should be tried together.
All right, that's on the docket for tonight. It is a case that we are, of course, watching very closely here at Court TV. No current trial date and nothing on the schedule, but boy, the next time they're in court, we'll be there with them. Stick around when we come back. The 13th juror. Good question here. Did a traffic stop in California get out of hand? Well, yes, it did. Whose fault was it? Be right back.
What are you waiting for, ma'am?
I'm waiting for my partner, ma'am.
For what? For a traffic violation?
Traffic stops are one of the most dangerous things
Okay,
we can
but
do.
you're making this dangerous. You're escalating it. Go give my son his ticket.
I will.
And we will take care of this in court. You will not be the judge and executioner on this property right here.
That was a situation that took place in Elk Grove, California, just outside Sacramento, where a 19-year-old young man blew a stop sign. A squad car was behind him, so the officer follows him, and he happens to be very close to his house. So he just decides, instead of pulling over, I'm just going to go 4 or 5 houses down the street, and I'll be home. So he does that, pulls up, goes across the traffic. You see there, he pulls up, and there he is. He's home, and his mother is outside. And then it gets a little bit out of hand. The officer comes out, the mother comes in and basically takes over and answers all the questions that the officer has for this 19-year-old. And it goes back and forth for a considerable amount of time. You heard a little bit there from the mother talking to the officer. There she is. She is taking control of this traffic stop. She does so from the very beginning, and she hands over her son's license and says, go back, write him a ticket, and be gone. No more. And the officer asks a few more questions. The tension rises here. Nothing happens. The officer stands there, though, and waits for backup. The question is, to our 13th jurors, did it get out of hand? Why and who is responsible for it? And let's go around and hear what you say. Callie says the young man is 19 years old, a legal adult. Why is his mother allowed to stand there and answer the questions for a grown man? I think she should be charged with interfering with the officer's job, just my opinion. I would never interfere with their job, specifically if I knew my grown kid was in the wrong. She knew he was. All right, Ecleynne, mom's looking out for her son, and and I don't know if you've seen the whole video. It plays out about 4.5 minutes. Mom is clearly concerned about her child and does not want any interaction between the officer and her child. What do you think
Yes.
of Kaylee saying, hey, the kid's 19?
Kaylee's obviously not black because she hasn't seen the news in which we've seen this go deadly quickly. And another thing, understand that this officer actually exacerbated the situation by having the Blue Lives Matter scarf over her face. So you already know, even if you didn't want to escalate it, just by that presence alone, understanding like who you side with makes it escalated. They are not elected. They can't be political on the job. You be political off on your off time, not while you're running a government vehicle. So I believe that alone kind of escalated the situation, and I thought the mom actually saved her son's life. That officer was terrified. Why? If she's that
Wait,
scared, she
Ecleynne,
should not have the job.
you think the mom saved the kid's life?
Yeah, I
This
do.
officer wasn't going to shoot him.
No, that's how we all think. But if he did not stop, if he did not get to his house, if he did not call his mom while he was turning, if he had the unfortunate, if he
Are you
was
saying that
unfortunate
every
to stop.
black person that's pulled over for running a stop sign is shot by the police?
No, but we are all scared of the same thing. Every time a cop comes behind me, I am terrified. I am terrified that this may be the last stop. I am terrified, and this is genuine. This is for real life. I am genuinely scared when the cops stop me or cops come behind me. I believe it's my last time being in this existence. This is what it's like being black.
Okay, well, you're not alone. A lot of people feel that way. Jeanette says, I received a few tickets in my life. Never once have I been asked if I was on probation or parole. That was one of the questions the officer asked this young man. I was given my ticket in a timely manner, and I went along my way. Never had a second, third, fourth, etc. cop car shown up. If the officer can't write a simple ticket without waiting for backup, then maybe she shouldn't be a cop. Andrew Warren, your take.
Yeah, de-escalation has to be the word of the day here. And you want officers to de-escalate any situation which potentially could get out of hand. And here, from what we know, it looks like the officer did the exact opposite. She reportedly had her hand on her gun. She asked the young man if he's on probation. She gets out of the car, she's asking for backup. She's wearing a Blue Lives Matter mask, which, as the police force recognized, is something that doesn't really project neutrality in these times. So she is escalating the situation through her behavior. I actually credit the mom with not trying to litigate what's happening right there, not saying, why are you pulling my son over? She's providing the documentation. She's saying, go ahead and write the ticket, and we will deal with this in court another day. Mm-hmm. So it's not like the officer, drew her gun or did anything that was egregious, but it's those incremental escalations that put people on the defensive. And here I think it was good that the mom stepped in, tried to de-escalate the situation, and make sure that everything was handled appropriately, and so that everyone can move on with their day.
All right, Teresa says first mistake was him getting out of the car per his mother, when everyone knows in a traffic stop you stay in your car. First thing cop said was stay in your car. First thing he did was get out of the car. Mother escalated the situation and blew it way out of proportion. Daryl, do you agree with Teresa? Was it the mom's fault?
I need to know more. I need to know when he blew through the stop sign or ran the stop sign. Did this police officer blue light him? Did she turn on her blue light? Because if she did, then he should have pulled over immediately. When he did pull over, if you notice, he was going the wrong way on the two-way street. And I think that the mom was a mom. Moms do that. And I don't care if you're black or white, they do that. But he should have stayed in the car. He should have followed what the police officer said to do. I don't like this. I don't like any part of it. But I need to know more before I can give you the answer that I'd like to give you, whatever that may be.
All right, Donna says, wow, that police officer should be fired. I don't blame that mother for her reaction after she stood there with her hand on her gun and then called for backup. That whole incident was totally unnecessary because of that officer, and I hope they sue her. All right, that's the final question or final answer of the day. We'll have to leave it at that. I want to thank the wonderful company we kept for the last hour, Ecleynne, Mercy, Andrew Warren, and Mr. SMART himself, Daryl Cohen. Appreciate your time, everybody. Appreciate you watching. Have a great night.